Mr. Levine.
Thank you very much, Mr. Chair and members. I'm pleased to present AB 2759. The need for this bill came to my attention as a result of constituent cases in my district involving a corporate fraud case where then Attorney General Jerry Brown said that these corporate criminals had callously swindled thousands of individuals out of $200 million to bankroll their extravagant lifestyles. The analysis does a thorough, accurate, and great job of laying out this issue and discussing the case. AB 2759 helps to compensate victims by making a much-needed clarifying amendment that allows for appropriate access to the Victims of Corporate Fraud Compensation Fund. The fund was created in 2002 in light of scandals involving Enron and other corporations. The fund provides restitution to victims of corporate fraud in cases where there is a judgment against a corporation. This limited award ensures justice is served and that victims are made whole to the greatest extent possible. Unfortunately, some victims have been unable to access the fund because the judgment must be against a corporation. This inadvertently excludes victims in cases where the judgments are against agents of a corporation, not the corporation itself. That is why AB 2759 clarifies that victims of agents of a corporation may be considered for compensation through the fund. Here with me today are Paul Ho and Val Hornstein, individuals who know all too well the detrimental devastation of corporate fraud. Paul is a victim of the infamous AGA financial fraud case that is not only considered to be one of the largest Ponzi schemes in California history, but affected thousands of North Bay residents, many of whom are from my district. Val is a lawyer who has represented more than 30 clients who are victims of AGI Financial.
Your first witness, please.
My name is Paul Huff, and I'm a resident of San Rafael, California, and a lifelong resident of this state. I am also a victim of the financial fraud perpetrated by Santa Rosa-based AGA financial advisory firm and by Asset Real Estate and Investment located in Redding, California. I am pleased today to support AB 2759, which broadens and clarifies eligibility for victims' compensation from the Victims of Corporate Fraud Compensation Fund. The expansion of compensation to those who have been victimized by agents of a corporation is necessary so that the fund operates as designed. Corporate fraud is indeed committed by its agents and not the corporate entity itself. The limited compensation the fund provides, often years after the losses occurred, allows some recovery, but often, indeed in this case, is only a partial payment for the misdeeds of these California corporations. In this case, and out of the over 1,000 households victimized in this state, I have encountered many situations of personal bankruptcy at a time when they were looking to retire, the need to resort to reverse mortgages to make ends meet, forcing seniors to go back to work at a time of retirement, and in the worst of cases, for some to contemplate suicide. This is what happens when savings accumulated from over 40 years of work is lost to the greed of individuals. The operation of this fund is critical in this, the largest state in the nation. Legitimate claims in an amount of not more than $50,000 should not be denied because they were victimized by agents of a corporation and not the corporation itself. I fully support AB 2759. It is a case of doing the right thing. And instead of always talking about doing the right thing, this is a chance to do it. I respectfully ask for your support for this bill.
Thank you. Next witness, please.
Mr. Chairman, members of the committee, and Assemblymember Levine. My name is Val Hornstein. And
speaking to the microphone, please.
My name is Val Hornstein, and as Assemblyman Levine said, I'm an attorney in the Bay Area. I've been practicing law for more than 30 years. A large part of my practice is representing investors who have lost capital for various reasons, oftentimes due to fraudulent conduct by investment advisors, broker-dealers, and parties like that. I've represented over 100 investors in such cases and dozens of dozens of cases throughout the state and elsewhere. I also represented parties in the AGA-AREI Ponzi scheme case that's been discussed by Mr. Huff and Assemblymember Levine. I have seen where victims of investment fraud have been uncompensated, and I believe that the VCFC fund is a good thing in this state. And I've read the Assembly Committee analysis of it, and I do support it. I think that expanding it as suggested in AB 2759 is appropriate and would help those investors in this state who have been defrauded of their investment capital and has very severely negatively impacted their livelihoods. And so I suggest an aye vote for this bill.
Thank you. Anyone else in support? Seeing none, is there any opposition? Seeing none, bring it back to the committee. Questions? Thank you. We do have a motion, and the motion is due pass to Banking and Finance. No other questions? Mr. Levine, you may close.
I respectfully ask for an aye vote.
Thank you. We do have a motion. Was there no second? Oh, there's a second. Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Alejo? Aye. Alejo, aye. Chow? Chu? Gallagher? Aye. Gallagher, aye. Weber? Holden? Mainshine? Aye. Mainshine, aye. Ting.
Needs one more vote. We'll put the bill on call.
Thank you very much, Mr. Chair. Thank you very much, members.
That brings us to item number 2, AB 1902. Mr. Wilk.
Thank you, Mr. Chair and members. On behalf of the 30,000 residents of Porter Ranch, California, I present to you AB 1902. As you're all aware, back on the 23rd of October 2015, SS well 25 blew in the Aliso Canyon gas facility in Porter Ranch, California. And there was a lot of coverage on the methane gas, and according to the LA Times, over 100,000 metric tons of methane was released into the atmosphere, which of course does affect global warming. Not reported as much, though, because methane is lighter than air. A lot of these other chemicals are heavier than air. So mercaptan, benzene, high levels of benzene. This is a former oil well, so petroleum fell into these communities. So in the ground, in the water, in the carpet, in the air ducts, on the curtains, what have you. Out of a community of 30,000, over 20,000 people, we had to be relocated because of health concerns, bleeding out of the nose, respiratory problems that never existed before, pets dying, just a lot of trauma. And 2 schools had to be completely relocated out of the area. I attended and participated in a lot of town halls. And one of the ones that was the most troubling to me is Governor Brown had his executive cabinet down there, and it was on a Friday night, 1,300 concerned citizens there. And during that process, I mean, obviously people are concerned about their home values. It's a very affluent area, but their number one concerns was the health care risk. Now, we're still going through the process to find out what happened. I'm pretty confident that our regulators didn't do the job they needed to do to ensure the safety of this community. And repeatedly during that town hall meeting, the regulators talked about how there is no long-term health care effects at all from the benzene, from the mercaptan, from the petroleum products. That's when I had the epiphany. We need to do something to restore these people's confidence in government because they don't have it. And so what this bill does is just extend the statute of limitations for those residents in that particular area to file a claim if over time they realize that there has been some ill effects caused by this. So this is a district bill focused on a community that has suffered a tremendous trauma, financial loss, and health care risk. And I respectfully ask for an aye vote.
Thank you. Do you have any witnesses in support?
I do not.
All right, is there anyone who wants
beautiful.
to speak in support?
Yes. Good morning, Mr. Chair. Enrique Roacho and members of the committee. Enrique Roacho with the Los Angeles Unified School District, and I apologize. We actually have a late support on the bill. As was mentioned, there were 2 schools as a part of the LAUSD school district that were impacted, and we're supporting a package of bills that aim to improve and increase oversight on these issues. And so for those reasons, we're here in support of the bill. Thank you.
So we do have a motion and a second. Anyone else in support? Is there any opposition?
Thank you, Mr. Chairman and members. Hal Dassinger with the Civil Justice Association of California. With respect, we oppose the extension of the 2-year statute of limitations for exposure to these toxic chemicals. We believe that the current 2-year statute of limitations is sufficient for the reporting of any claims from injuries from this exposure, particularly as pointed out in the committee analysis with the delayed discovery rule. There's time for the patient or plaintiff over time to generally accumulate the facts that they need to get to the point where they're on inquiry notice, starts the statute running, and then they have 2 years from that point. We believe that's sufficient. We urge a no vote.
Thank you. Anyone else in opposition? Seeing none, I'll bring it back to the committee. Mr. Wilk, we ask you to take amendments that would extend the statute of limitations for anyone else who had been exposed to similar toxic materials. Are you willing to take that up?
I am not. I view this as a district bill. I view this as an opportunity to restore some faith in our state government. That's a broader conversation that I'm open to, but not in this particular bill.
Okay. Well, I think if we do that just in this case, given the fact that there are exposures across the state, I think that if we pass this, it undermines your goal of restoring faith in government if we're going to pick and choose who's been poisoned, who's been not poisoned, and what we're going to do for them. Therefore, I'm going to have to recommend a no vote on this bill. Other questions, comments from the committee? All right, seeing none, Mr. Wilk, you may close.
Again, appreciate the opportunity to present. The opposition admitted that this is toxic chemicals. I think it's well documented. Again, we don't know what the long-term health care effects are. Our regulators failed at protecting our residents based upon what's happened. They have said that there's no long-term health care effect at all. If that's the case, there's no reason not to extend the statute of limitations because they should have no concerns at all. So again, I think hopefully we'll do what's right for my residents. I support people's district's bills, and I would hope that this committee would give me the same consideration here today, and I ask for an aye vote.
Thank you, Mr. Wilk. There has been a motion and a second. The motion, I'm assuming, is due pass. Call the roll, please.
Stone?
No.
Stone, no. Wagner? Aye. Wagner, aye. Alejo? Alejo, no. Chow? Chu? No. Chu, no. Gallagher? Aye. Gallagher, aye. Weber? Holden? Mainshine? Aye. Mainshine, aye. Ting?
You have 3 votes. You need 3 more. We will put it on call.
Thank you, Mr. Chair and members.
Mr. Alejo, AJR 32.
Thank you very much, Mr. Chair and members. Thank you for hearing this important measure. AJR 32 calls upon the United States Senate to fulfill its constitutional obligation. I just want to take a moment to say that the death of Justice Antonin Scalia in February is a loss to American jurisprudence. But a well-functioning federal government, as well as state governments, require a fully manned and functional U.S. Supreme Court. In the 2 months since Justice Scalia's death, several high-profile cases before the court have already been subject to 4-4 ties. Without a fully manned 9-justice court, the country is subject to 2 harmful effects. First, it allows for the possibility that conflicts of law that arise between the various federal courts of appeal go unresolved by the Supreme Court. Without the tie-breaking function, the application of federal law may differ between, say, California and Texas. Second, it means that important issues of national importance go unresolved. The recent Fredericks case, an attack on labor unions and working people, is an example. Without the finality provided by the court, important legal, social, and political questions will remain in limbo. I want to be clear. I am not calling upon the Senate to nominate President Obama's nominee. I would certainly be pleased with that outcome, obviously, but that is not what AGR 32 is about. All this resolution does is call upon the Senate to do its job. Article 2, Section 2 of the Constitution empowers the President to nominate, among other official justices of the Supreme Court by and with the advice and consent of the Senate. The Senate provides neither advice nor consent when it declines to even provide the President's nominee with a Judiciary Committee hearing, never mind a vote on the floor of the Senate. Here are the facts. Multiple justices have been confirmed during an election year, the most recent of which was Justice Anthony Kennedy under President Ronald Reagan. In fact, since 1900, 6 justices have been confirmed during the election year, and since 1875, since just after the Civil War, every Supreme Court nominee has received a hearing or a floor vote, except those whose nomination the President withdrew beforehand. All this resolution does, again, is call upon the U.S. Senate to give the President's nominee a fair hearing and a floor vote. This is the time in nearly 150 years that the Senate has completely abdicated its constitutional duty. The functionality of the federal government and the integrity of American law should not be held hostage by a group of senators who are putting partisan politics above principle. With that, I respectfully ask for your aye vote.
Thank you, Mr. Alejo. Your witness, please.
No witnesses.
No witnesses. Anyone else want to speak in support of the bill? Seeing none, is there any opposition? Seeing none, bring it back to the committee. It is ironic that in replacing such a strong constitutionalist, that the federal government doesn't seem to be willing to follow the Constitution in this case. So I appreciate you bringing this forward. Other questions, comments, Mr. Wagner?
Well, first of all, there's clearly no obligation on the part of the Senate to actually hold hearings. It can exercise its advice function without holding hearings. Most of our justices in the history of the United States were appointed without holding hearings, and the fact that they choose not to do so in this case is in no way a dereliction of constitutional duty. We've also seen numerous times where federal judge appointments have been judges have been nominated, but then the court has not seen those judges ever get a hearing, much less a vote. The Democrats, when they controlled the Senate in 2008, refused to take action on the Republican president's nominee of Robert Conrad for a fourth Court of Appeals position. We all know what they did to Miguel Estrada for months and months and months, and by they I mean a Democrat-controlled Senate. We know the current vice president, when he was chairman of the Judiciary Committee in 1992, or a senator in 1992, suggested during the election season there be no hearings, much less votes. His call to do nothing was echoed by the then chairman of the Judiciary Committee, Senator Leahy. And so when the shoe has been on the other foot, there's certainly been no hue and cry of constitutional dereliction of duty. This is an election year stunt in our House, and I find it just amusing that Democrats in this body would think Republicans in the U.S. Senate would give a rip about this silly little ACR. I'll be a no.
I want to thank the author of this ACR for bringing it forward. As someone who worked for the Senate Judiciary Committee years ago and worked on Supreme Court nominations and other judicial nominations, I don't think we need to get into a back and forth, but I certainly would point out that I think the number of judges that have been stalled by the majority certainly outweighs what was just suggested. And that being said, we know we are stalling justice here. The potential for 4-4 votes on the Supreme Court this year is very, very troubling. And with that, not only happy to move this forward, I had actually thought about introducing the same thing until I saw the good author move this. I'm happy at some point if you would like to add me as a co-author. But I do hope that we will at least get an answer from the Senate with regards to its advice and counsel prerogatives before the year is up.
Thank you. I'll take that as a motion.
Correct.
Do we have a second? We do have a second. Mr. Gallagher.
Well, first of all, I do appreciate the comments about the late Justice Scalia from both the author and the chairman. As you said, it's a loss to our jurisprudence. Certainly, people may disagree with some of the outcomes of where he came out on cases, but nobody could disagree that he was a great legal mind and always in adherence to the Constitution. And that was recognized by his colleagues, including his best friend on the court, Ruth Bader Ginsburg. I think what we're talking about here in a lot of this debate is that there are a lot of people who would like to see someone of a similar philosophy replace Justice Scalia, especially those of us who have a strict constructionist view of how you interpret the Constitution. So, all the time a legislature can act by not acting. There's many times that we in our own body don't take bills up or they don't get out of committee. We decide to leave them inactive. We act essentially by not acting. I don't see how this is really any different, and for us to sort of tell another body how they should or should not act is, it's really up to them. That's their prerogative, and the exact language, since we're talking about how to construe the Constitution, is that the Senate has to provide advice and consent. And so my question to you would be, can't they withhold consent by just not taking the appointment up?
What I would respond to your comments and to Mr. Wagner is that we weigh in on a wide range of issues, local and international issues, and this body, our legislature, has weighed in on numerous issues that have gone before the Supreme Court. If Mr. Wagner doesn't take this seriously, certainly the American people do. 63% of the American people want to have a hearing on the next nominee for the Supreme Court, not next year, now. American people have spoken. They want to see this move forward. They see this as a responsibility of not only the president but the Senate, and and they should at least hold a hearing on this nominee. Numerous elected presidents have taken this position, from President John Adams in 1801 to President Reagan, and the last rejection where it was actually up for a vote before the Senate was Robert Bork, of course, in 1986. A year later, they instead appointed Justice Kennedy. But that was the last time a Democratic-controlled Senate rejected someone, but they gave it a fair hearing for a Supreme Court nominee. Now we're weighing on behalf of our constituents, the people that we represent, and in the state that has the state that has a big stake in the decisions made by the Supreme Court, to weigh in. And in the past, we did it most recently with one person, one vote, and that was Senator De Leon's resolution. It was similar to the Supreme Court, and guess what? It was unanimously agreed with what the message that this body, this assembly, this Senate sent to the Supreme Court, that they should be able to draw boundaries based on people, not just voting citizens. But we weighed in with the Supreme Court in the past, whether it was allowing undocumented students, law students, to be able to obtain their bar license, or whether it was the elimination or the pre-clearance requirement of the Voting Rights Act of 1965. We weighed in many times to the Supreme Court because those issues are important for us and for our constituents. And we're not doing our jobs as legislators if we see an issue of national importance and we're not being a voice for the people that we represent. And that's what we're doing here. And I take it seriously. Mr. Wagner may not, but this is really important for the state of California. And it's certainly important to the American people to have the president's nominee receive a hearing.
It's just as a follow-up question to that is, I think we can all have a reasonable discussion about whether or not they should take up the vote and have an up or down vote. And I take it very seriously as well, Assemblyman, and I know you do as well. We could have a reasonable discussion about that, but the question is whether or not they have to. And as Assemblyman Wagner said, Senator Biden The president, when he was a senator, also took the position that we don't have to take up appointments that we disagree with. Are they wrong when they said, when they were in the capacity of senator, that we should block nominations, that we should do everything we can to stop nominations that we don't agree with? And again, that's the point. Do they have to? I don't think they have to. And for us to tell them what they, have to do, I think is sort of out of bounds, right? I mean, so again,
not.
is that wrong?
We're weighing on.
Were they wrong?
We're weighing in. We have 2 U.S. senators that represent California, and the most powerful state in the nation could certainly weigh in, not only what we want to express to our own 2 U.S. senators, but to also senators across the country. This is unprecedented. Every nominee has been given a hearing. The Judiciary Committee should be allowing a hearing in Congress, and that's what in the Senate, and that's what we're asking to do with this resolution.
Anything further? All right. Additional questions or comments? All right. Seeing none, you may close.
I respectfully ask for your aye vote.
All right. Let's take a vote.
Stone? Stone, aye. Wagner?
No.
Wagner, no. Alejo?
Aye.
Alejo, aye. Chow? Chu?
Aye.
Chu, aye. Gallagher? No. Gallagher, no. Weber? Aye. Weber, aye. Holden? Yes. Holden, aye. Mainshine? Ting? Aye. Ting, aye.
6 votes, it's out.
Thank you very
For
much.
all the good it'll do. All right. What do we got left? All right. We have several bills on call. We'll take those up since the only bill we have left is Mr. Stone's committee bill. All right, we're on consent. All right, on the consent calendar, call the missing members.
Chow? Weber? Aye. Weber, aye.
Let's go through each one. All right, just in order. AB 1887, Low.
That's
Call the
item-
missing members, please.
Item 1, votes 3-2. Chow? Chu?
Aye.
Chu, aye. Weber? Aye. Weber, aye. Holden? Aye. Holden, aye. Ting? Aye. Ting, aye.
That bill is out. Item 2, AB 1902, Wilk. The vote's 3-3. Call the missing members, please.
Chow? Weber? No. Weber, no. Holden? No. Holden, no. Ting? No. Ting, no. That bill fails.
That bill fails. Item 3, AB 2003 by Lackey. Vote is 2-4.
Alejo? No. Alejo, no. Chow? Weber? No. Weber, no. Mainshine? It has 6 no votes for it, so it fails.
That bill has 6 no votes, also fails. AB 2498, file item 5 by Bonta.
Chow? Chu?
Aye.
Chu, aye. Weber? Aye. Weber, aye. Holden? Aye. Holden, aye. Mainshine? Ting? Aye. Ting, aye.
That bill is out. Item 6, AB 2566, Nazarian.
Chow? Chu?
Aye.
Chu, aye. Weber? Aye. Weber, aye. Holden? Aye. Holden, aye. Mainshine? Ting? Aye. Ting, aye.
That bill is also out. Item 8, AB 2759 by Levine.
Chow? Chu?
Aye.
Chu, aye. Weber? Aye. Weber, aye. Holden? Aye. Holden, aye. Ting? Aye. Ting, aye.
All right, that bill is also out. We're still waiting for Mr. Stone, who has a bill in public safety. He'll be back shortly, I hope. And additional members, if they're... Hang on just a second. Additional members, if you're out there, want to get down here for a vote, I'd encourage you to do so soon. Oh, okay. That's not on call. That bill was out. But if we can do some add-ons. We have a few minutes. Okay. Let's just go through the rest of the bills and do some add-ons.
Item 1, AB 1887. Chow? Aye. Chow, aye. Item 2, AB 1902. Chow? No. Chow, no. Item 3, AB 2003. Chow? No. Chow, no. Mainshine? Item 4, AB 2101. Chow? Aye. Chow, aye. Weber? Aye. Weber, aye. Ting? Aye. Ting, aye. Item 5, AB 2498. Chow? Aye. Chow, aye. Mainshine? Item 6, AB 2566. Chow? Aye. Chow, aye. Mainshine? Item 7, AB 2707. Chow? Aye. Chow, aye. Weber? Aye. Weber, aye. Ting? Aye. Ting, aye. Item 8, AB 2759. Chow? Aye. Chow, aye. Item 10, AJR 32. Chow? Aye. Chow, aye. Mainshine? Consent? Chow? Aye. Chow, aye.
Seeing no objection to Mr. Alejo presenting the Judiciary Committee bill, sir, you may. Mr. Stone. Ha.
No, thanks. Yeah, they're. Hopefully, we're not going to upset Mr. Jones Sawyer too much as they work through their last bill. Thank you.
Certainly.
So 282 is the family law omnibus bill. It's doing three things. It's providing the subordinate judicial officer conversions. It is addressing the issue of child support in arrears. There's a current program that puts on hold someone's child support obligations while they're incarcerated. That program has been successful and needs to continue. We're just trying to continue that in this case. And then other minor updates and technical corrections to marriage establishment, adoption, and Department of Social Services provisions. From here, this bill will go to appropriations. It's intended to be cleanup of existing issues that we have found in the family law arena. And with that, I ask for your aye votes.
Thank you. Witnesses in support.
Amanda Wells on behalf of the Judicial Council in support of the portion of the bill relating to subordinate judicial officer conversions. Happy to answer any questions.
Thank you. Additional witnesses in support. Any witnesses in opposition? Questions or comments from the committee? That was a much better job than Mr. Alejo could have done.
I don't think so, but that's great.
You may close.
Thank you. I request your aye vote. This is our bill on family law.
Okay.
Thank you.
And this is due pass to appropriations.
Yes.
Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Alejo? Alejo, aye. Chow? Aye. Chow, aye. Chu?
Aye.
Chu, aye. Gallagher?
Aye.
Gallagher, aye. Weber? Aye. Weber, aye. Holden? Aye. Holden, aye. Mainshine? Aye. Mainshine, aye. Ting? Aye. Ting, aye.
Quick housekeeping matter. May I request reconsideration for the Wilk and Lackey bills, please?
Yes, without objection, we will allow reconsideration.
Thank you.
And then, Ms. Wagner, if you don't mind, I'm going to go back to public safety where I should present. We'll hold the roll open. So if you don't mind presiding over making sure that we're getting bills off call and any additional votes. I'll be back as soon as I can.
Got it. Thank you, Mr. Chairman. I think Mr. Mainshine is the only one who hasn't voted yet, so if you would call the votes Mr. Mainshine has missed, and then we'll be done.
Item 3, AB 2003. Mainshine? Aye. Mainshine, aye. Item 5, AB 2498. Mainshine? Aye. Mainshine, aye. Item 6, AB 2566 by Nazarian. Mainshine? Aye. Mainshine, aye. Item 10, AGR 32, Mainshine.
We are done and adjourned. Thank you all.